The following is a workflow for patenting. Whether you come up with a potential patentable research result, IP manager, who is me at NIG, will discuss and analyze the inventions. Then, whether or not to file a patent application is examined by the IP committee in university. In particular, novelty, inventive step, and industrial applicability are considered as patentability. Most university inventions are basic and applicability can be a problem. However, there are many cases in which it is necessary to obtain intellectual property, even if it is somewhat basic. Although it takes time to do so, it is important to consult with the patent attorney at the patent office to determine what kind of claim is best for you. And this point, it is important to think about the claims that match with the actual licensing process. Once you have applied for a patent, it is a time to negotiate with interested companies and license them. Negotiations at this point requires a great power. In addition, you will need to discuss filing overseas applications for patents and maintain the patents. When licensing a patent, whether to license it exclusively or non-exclusively is very important to your patent strategy. Because an exclusive license to an unsuitable company would render the invention and patent unusable. If a company come along later and pay you more money, you will be disappointed. Startups, venture company, want exclusive license because they want to be competitive. We look at the exclusive license very carefully. In some cases, we also use the exclusive but delimited field of license approach. Especially in the case of the basic research result, we use a non-exclusive license when possible.